The next case is 23-40001, Seago versus, I'm not sure I can pronounce that, the Acting Commissioner of Social Security.
May it please the court. My name is Mahesha Subbaraman. It is my privilege to represent Social Security claimant Emily Seago. This case is about the Federal Vacancies Reform Act, or FVRA, and whether in July 2018, Acting Commissioner of Social Security Nancy Berryhill was serving in accord with the time limitation that the FVRA imposes under Section 3346A on acting service. Section 3346A imposes a 210-day limit on acting service, subject to an exception for when the president submits a nomination to the Senate to fill a vacancy. Seago maintains that Section 3346A is best understood as a uniform 210-day clock and a near tolling provision, which means that an acting officer may serve during a pending nomination if, and only if, the president submitted the nomination before the 210-day clock expires. That condition was not met in Berryhill's case, invalidating her July 2018 acting service. Now, the government maintains that Section 3346A enacts two entirely independent service periods, which means an acting officer may spring back whenever the president makes a nomination, even if that nomination takes place months, years, or decades after the 210-day clock has expired. Now, the Eighth Circuit and the Fourth Circuit have each issued decisions embracing the government's spring-back reading. This court should reject those decisions.
How could it be decades? Because I thought it starts over again with a new president.
Well, you're right, Your Honor.
I guess you could have a really young president who runs decades later.
Perhaps something like that.
Probably not.
No danger of that.
The Eighth Circuit and the Fourth Circuit have issued decisions embracing the government's spring-back reading. We think that the court should reject those decisions because they evince a wholesale disregard of the rules of statutory interpretation.
I guess I'd like you to, I mean, that's so, I appreciate you got to the nub of the issue, which is you've got two circuit courts who haven't agreed with this position. So if you could just sort of zero in on, well, why are they wrong? I mean, we don't like to create circuit splits.
And I'm going to lump them together to a certain extent because I think that their reasoning overlaps in significant extent. But I think it's fair to say that the Eighth Circuit builds its interpretation of the FVRA's time limitation on essentially two main pillars. The first pillar is the use of the word or to join 3346A1, which is the 210-day clock, and 3346A2, which is the pending nomination text. And they say, well, or is disjunctive in nature, and therefore that means these two provisions must be independent. But as Justice Gorsuch points out in the Lac de Flambeau case, or can either have an exclusive or an inclusive meaning. Now, the government tots out the hackneyed example of if a waiter offers you tea or coffee or tea or dessert, that a patron would recognize that you can order tea and dessert. But if you change just a few words in that hypothetical and you say the waiter offers you a free coffee or a free dessert, no reasonable person would assume that the waiter is inviting you to have both a free coffee and a free dessert. So context matters when you're interpreting whether or operates in an inclusive manner or an exclusive manner. The Eighth Circuit assumes it operates in an inclusive manner, but doesn't really provide all that much justification for why that's true. By contrast, in our briefing before this court, we explain why it should not be presumed to operate in an inclusive manner. And we provide kind of three main reasons for that. First, we point out the fact that when Congress has wanted or to operate inclusively, it has expressly said so in other statutes. The two prominent examples of this are the Bankruptcy Code, 11 U.S.C. 102.5, where it has expressly said, or is not exclusive, and in a historical note is clarified. We're trying to get away from the mutually exclusive meaning of or. That type of definitional section demonstrates Congress's understanding that or is by default exclusive, and if or is by default exclusive, then Congress needs to say something to make it inclusive. So that's one argument, that Congress knows how to do this. The other, another way of looking at it.
So on that argument, what would Congress have needed to say, in your view, in 3346A to achieve that?
Well, there are a couple things they could have done. One thing they could have done is they could have, in 3346, as they've done in other sections of the FVRA, simply had a definitional section which said, or in this section shall not be read exclusively. That's what they've done in the Bankruptcy Code. That's what they've done under the Federal Debt Collections Act. They could have done the exact same thing here, and there are definitional sections in other provisions under the FVRA. In 3345 and in 3348, they define various terms. They could have done that in 3346. Another thing that they could have done, and this is pointed out by Judge O'Connor in the Miller decision that we cite, is they could have used the language one or both. And you see that throughout the U.S. Code. Whenever you have a two-item list, oftentimes Congress will say, you may do one or both of the following. So if Congress had wanted to write the prefatory language of 3346A to say an acting officer may serve for one or both of the following periods, that would have solved the problem as well. And then finally, it could have simply used the word and. And that gets to the last reason why I don't think you can presume that or operates in an inclusive manner. Because if you make that presumption, you run into the anti-surplusage canon, which teaches that you should essentially give meaning to every word. And the problem that you run into with saying that or really operates to allow both of two options is there's no difference then between that reading and a reading that says the word and is there. And that's a point that Judge Willett makes in his Palomares dissent. He says, if you read or inclusively, then you're not reading it any differently than if the word and appeared between the two things that are being connected, or if nothing appeared there at all. And at that point,
suggest you never read it inclusively.
so I think,
Will it really say that?
There may be some context where it's just so clear, like a tier dessert situation where you could say with some certainty that it's inclusive, but I think Congress has demonstrated throughout the U.S. Code that when it wants or to operate inclusively, it says so. And that's the bottom line of it. And that's analysis that appears nowhere in the Eighth Circuit's decision. They simply don't reckon with that issue. The other pillar of the Eighth Circuit's decision is the question about what do we do with this prefatory language, the person serving as an acting officer, as described in Section 3345, may serve in the office. Now, we argue that the use of the present participle serving means that the person has to be currently serving at the time that either of the triggering events under A1 or A2 are applied. So the question becomes, if A2 is going to be applied, was there an acting officer serving when President Trump made his nomination in April of 2018? And the answer to that question is no. Barry Hill was not serving as an acting officer, and we know that as a matter of law because the FVRA foreclosed that office under Section 3348B1, and we know it as a matter of fact because she said, I'm stepping down from this position in March of 2018. So the language serving, we attribute a currency to it. And we think that's consistent with what this court in the Nickel case and what the 11th Circuit in the Westchester case and what the 8th Circuit in the BNF SF Shell Railway case has said, and what the 10th Circuit has said in the Kakan case, that when you're dealing with present participles, you give them...
I'm going to ask something
Sure.
slightly different. I understand your argument that presidents need to be making their nominations during the 210 days, and otherwise it just makes it really easy for them. Well, when Saul was nominated, it wasn't confirmed for over another year. So the problem is, I understand the presidents should be nominating promptly. I respectfully also suggest that the Senate should be confirming or not voting promptly, but that isn't up to us. And let's just say, what if the president did nominate someone and it's 3 years later and nothing's happened? Then you're saying that under Lucia, there would have been no ALJs, and so nothing can get done. And so the country's just going to kind of not have Social Security going on.
Well, respectfully, Your Honor, I don't think that that's the case. And I also think more significantly, the reason why Congress wanted there to be such consequence to the president making that nomination during the 210-day period is to put pressure on the president afterwards to say, look, if I miss the 210-day period and we really need to get someone in there pronto, then he needs to make that nomination on day 211, 212, et cetera, et cetera. He can't wait 5 months. He needs to act with speed,
But
and
then-
then the Senate needs to act.
Senate waited over a year, and the president doesn't have any control over that, and we certainly don't.
That's true, Your Honor, but it's entirely within Congress's ken to write a statute that puts pressure on the president and that puts pressure on the Senate and says to the people, look, if we don't get our act together and do things on time, then you can hold us accountable at the ballot box for that. But fundamentally, as part of our constitutional structure, we're not supposed to have acting officers camping out in these positions ad nauseum, and that's what we have when the time limitation doesn't operate in the manner that we've described. And you see that, and I know the court is loath to look at legislative history, so I won't go too far down this road. But if you look at the Senate committee report that accompanied the initial draft of the FVRA, which did have a springback provision, one of the repeated refrains of the Senate Committee on Government Oversight in that report was the president, under previous versions of the Vacancies Act, was not making timely nominations during the period of time that we were affording him to allow an acting officer to serve. So we need to do something to give him a swift kick in the butt, forgive me for saying so. And there's nothing more we can do other than to add a real enforcement mechanism with some real teeth to it. That said, I want to briefly return to the presently serving point because I think it's an important one. The Eighth Circuit basically said, we don't have to afford this statute its ordinary meaning because doing so would create an impossibility. It would mean, if serving means presently serving, then a person would have to be serving before the 210-day clock started, since that language applies to both 3346A1 and 3346A2. We show conclusively in our brief that is eminently possible. That, in fact, that is exactly what happened in Barry Hill's case. She was serving from January 2017 to April 2017 properly as an acting officer under the FVRA, under the transitional inaugural period of 90 days that the statute allows, before the 210-day clock started. And we provide other examples of how it is entirely possible for a person to be serving before or at the time that the 210-day clock starts. So there simply isn't an impossibility that precludes giving this language its plain meaning. And if there isn't an impossibility, then essentially what the Eighth Circuit, and by extension the Fourth Circuit, is doing is rewriting the plain language of the statute to suit its own sense of what it thinks the statute should.
Yes, I hear what you're saying. I'm a little worried about taking one participle out of and not looking at the whole context, because it doesn't just say serving, it says serving as an acting officer as described under section 3345.
I think that's absolutely true. And I think there are two helpful ways to address that point. One way is to say, well, what if we erased some of that language? Would it get it closer to the kind of provision that the government argues that this should be read as? And it would. If you delete the words the person serving as, and it just said an acting officer as described in section 3345, there's no temporal quality to that, and it could describe pretty much anyone. But Congress included those 4 words there for a meaning, for a reason. Beyond that, we sentence diagram in our brief all of the words.
4 words are the person serving as.
So it's the person serving as, but if you look at beyond serving to words like the, which is an article that's designed to denote a particular person, and cases like Rumsfeld versus Padilla, which speak to the use of a definite article versus an indefinite article, they all ultimately kind of circle around the notion that we have a present tense usage throughout this statute. And when Congress has repeatedly used the present tense over and over and over again throughout a statute. This court's cases, for example, in Iran, talking about the bankruptcy code's use of a repeated use of the present tense and talking about the Comey status, that means where is the debtor located now, not where was the debtor located 5 years ago. So I get the point that you're making. The other way I would resolve that point is by looking at our reply brief and the 8 additional textual clues that we speak to, which all support the interpretation that we're giving. So you don't just have to rely on the person serving as. You can look at, for example, as the Foster decision in the District of Arizona points out, the fact that 3348C, the provision that talks about extending the 210th day if the Senate happens to be in recess, that would be completely superfluous under the government's interpretation versus our interpretation. There's no reason to extend that period unless it operates as a 210-day clock and a tolling provision. I see that I'm out of time, but I'm happy to answer any other questions the court may have. I hope I didn't speak too fast.
You're fine.
May it please the court, Joshua Salzman, on behalf of the Commissioner of Social Security. I'd like to start where Judge Duncan was discussing earlier. Why did unanimous panels of the Fourth and Eighth Circuit think, just on the basis of plain text, this statute authorizes discontinuous service? And obviously, both of those courts put a lot of emphasis on the word or, but I think my friend did not give due credit to their analysis in saying that they just blindly applied a presumption that or is always what we'll call an inclusive or, an and or provision, that A1 says 210 days, subsection 2 says, or once a nomination is made, acting service is allowed from the date of that nomination while the nomination is pending before the Senate. And I think the Fourth Circuit's analysis on this was really good. They looked at these two provisions and realized they operate independently. They each have a start date and they each have an end date. And if you want to talk about the canon of surplusage, if you want to talk about how do you make sense of this statute, I think that start date in A2 is something that they have no explanation for, because on their telling, if it always has to be continuous service, then the start date is always going to be the emergence of the vacancy, and then A2 could extend the end date, but it doesn't have any reason to have its own start date. And that's something that the Fourth Circuit appreciated in saying that these two provisions stand on their own, and in context, that or needs to be read inclusively. And in fact, I think this idea of an inclusive versus an exclusive or is a bit of a red herring, because nobody thinks it's an exclusive or. My friend doesn't think it's an exclusive or. He doesn't want to allow for service just once a first or second nomination for the office is submitted from the date of the nomination for the period that the nomination is pending before the Senate. He wants service under both provisions. He says you can have the 210 days, and then he reads A2 as somehow subordinate to A1 as having this gloss that allows it to extend the period, but not to restart the period. But no.
You address the issue of this is Congress trying to get the president to be more efficient in making nominations more quickly. Of course, it doesn't push the Senate, but if you make the nomination during the 210 days, then if the Senate delays, we've still got somebody in the bucket.
Yeah, so I actually think that consideration absolutely pushes in our favor. There's no question Congress wanted 210 days and to provide encouragement. But everybody agrees that there's a penalty if you don't nominate in 210 days. On day 211, the office has to be vacant. Nobody can exercise the duties of that office. The question is different. What happens if, for whatever reason, the president misses the cutoff? Do you want it to be irreversible? Or once the president belatedly does his unilateral part in the nomination process, and any further delay is on the Senate, not on the president, as I thought Your Honor pointed out earlier, at that point, Congress would, if anything, under my friend's reading, Congress would be holding a gun to its own head, because at that point, though you pointed out, these ALJs needed to be appointed in the wake of Lucia. You don't want the Social Security system to shut down. At that point, Congress wouldn't be putting pressure on the president. It would be putting pressure on itself, because it would bear the responsibility. And if the president made a nomination, for example, that the Senate didn't want to otherwise approve, it might have felt pressure to just accept the president's nominee or to bear the costs of the Social Security administration not being able to operate properly. So everybody agrees there's a penalty after 210 days. The question is just, can you fix it? Once the president belatedly does his part and makes the nomination, would Congress have wanted the system to shut down? So I think all of the practical concerns point in favor of our reading of the statute that allows discontinuous service. And of course, I also think.
Well, I mean, logically, they could have. They should just, it's a bargain that's struck. All right, the president has to act, and we have to act if it gets strung out. I mean, that's conceivable.
I do, Your Honor, and of course, Congress was trying to impose a penalty here. The question is, how draconian and how irreversible did they want it to be? And the other point, as I said, I do think that these considerations balance in favor of our reading, but our primary argument and what the Fourth and Eighth Circuits relied on pretty much exclusively was just plain text. And it's just the best reading of that word "or," which is has both the inclusive and the exclusive sense, and also that inclusion of a start date in the A2 subsection, saying it's once the nomination is made, not if the nomination is made before the clock expires, but once, which I think is best read to mean whenever. You get it from the date of the nomination. And again, they can't explain that start date in A2. I also want to briefly touch on this question of, should this have been an and? Would the statute have been clearer with an and instead of an or? And I'd submit that it would not be, because what and would do is join the two provisions and potentially introduce a requirement that in order to serve under A2, you'd need to have service under A1, because there would be a linkage there. And one benefit of our reading, and one thing I think the or makes clear, is that the two provisions operate independently. So let me give you an example of how this can happen. Let's say a vacancy emerges in an office, and the first assistant to that office, who is the person under Section 3345, who would normally automatically be the default person to execute the duties of that office. If that first assistant position was vacant, and the president didn't identify an alternative acting official, the office could be vacant for 210 days. But then let's say so nobody had served under A1. We would say acting service is still permissible under A2, even if there had never been an acting official under A1. If the 210 days ran, the president made a nomination, then somebody could serve. I think that question would be in doubt with an and, because it would link the two provisions. Whereas here, when you have this prefatory clause with the M dash at the end, and then the or, what that tells us is we can just skip over A1, and nothing in A2 refers back to A1. The or confirms that they operate completely independently, and as a result, the best reading is to allow A2 to stand on equal footing with A1 and authorize acting service once a nomination is made.
Do you think it's worth putting any weight on there's A2 has a preface subject to subsection B. What I don't recall in your brief if you make any hay of that.
We don't. What we point out is subsection B addresses what happens if the nomination is returned or fails. And it provides for an additional 210 days. And I don't think it affirmatively helps either party. I think it's addressing a permutation of how these things can go that didn't happen here. Andrew Saul's nomination was not ultimately.
Well, it is a limit on A2 that I guess, I mean, in logic doesn't apply to A1, right? I'm not sure if that's right.
I'd have to think about that, Your Honor, but I don't think we need that to win this case. I do briefly want to talk on the surplusage argument. They argued that there's a provision in 3348 that wouldn't make sense under our reading because it suggests that Congress cared a lot about calculating exactly how the 210 days would be computed. As I think I said earlier, under our reading, the 210 days is very meaningful because, make no mistake, under everybody's reading, unless a nomination is made, the 210-day clock cuts off the permissible period of acting service. So there would be, if the Senate was in recess when day 210 came around, there would, under our reading, potentially be days or even weeks, depending on the length of the recess, when nobody could serve. So I think they're just wrong in saying that our reading would make that provision superfluous. And I think the Foster District Court they rely on just missed that point. I think I've touched on most of the key statutory considerations. Obviously, the word serving, as we've explained, serving is part of a broader phrase, serving under Section 3345, and I think our brief explains why that's the best reading of that. Unless the panel has any further questions, I'm happy to rest on my brief. Thank you, Your Honors.
Judge Duncan, I want to start with the observation that you made regarding subject to subsection B, because I think that's really important. If you look at our reply brief, we addressed that both in our introduction and in the 8 textual clues that we identify that support the tolling-based interpretation. The reason why that language matters is because it indicates that there's supposed to be a consistency in terms of how you read each of these provisions, the 210-day clock, the first nomination period, the second nomination period. And what is really strange about the government's reading, and for that matter, the 8th Circuit and the 4th Circuit's reading, is they all concede it's a tolling provision if the president makes a nomination during the 210-day period. But then it magically becomes a springback provision if the president makes a nomination after the 210-day period. But then if we're into the second nomination periods, it's a tolling provision once again, because those provisions under subsection B talk about the person serving as an acting officer may continue to serve. And as the courts, or as the government's own authorities, a case called Bauer, for example, concedes, that would seem to indicate someone had to be already serving in order to benefit from the additional periods of time authorized by subsection B. So respectfully, Your Honor, we think that that language only goes to show the ultimate point that we're making, which is to read the statute to kind of be this on-off switch, which turns the statute from one thing into its exact opposite at the same time, just makes no sense. And that's part of the reason why we emphasize the Supreme Court's description of 3346A2 in the NLRB case as a tolling provision. And quite frankly, we think the 8th Circuit and the 4th Circuit don't pay the proper respect to that description that should be accorded to it. There are a couple of other points that I quickly want to address. One point is my friend on the other side seems to say no one agrees that this is an exclusive or. That's simply not true. We believe it is an exclusive or, and the reason we believe it's an exclusive or is because if a person is serving during the 210-day period, they're serving under that period. If the president makes a nomination during the 210 days, they're not serving under 3346A1 anymore, they're serving only under 3346A2. Otherwise, if the 210-day clock is continuing to run and A2 has no effect on that clock, you have a weird problem when you hit day 210. So you're either serving under A1 or you're serving under A2. But once you've exhausted A1 and you've served your 210 days and there's no nomination, A2 becomes unavailable. And you have things like the Mort-Rosenberg CRS report, which confirm that interpretation 12 days after Congress passed the statute. Now, the other point that I kind of want to speak to is the government argues that A1 and A2 should be read completely independently, because what if the president doesn't nominate anyone at all during the 210-day period to serve even as an acting officer and lets that 210-day period go? Well, the government argues that's all the more reason why A2 should be understood independently. But that, respectfully, is not how Congress, in any way, shape, or form, understood any of this language. When you look at the Senate committee report in this case, it emphasizes that Congress, to the extent it was contemplating any form of springback, was saying, look, if the president nominates someone, we want the person to be able to resume their service. That's always how they described the draft language in the initial version of the FVRA that did have a springback provision by saying the office shall remain vacant until the president submits a nomination. That language disappeared from the final version of the bill, likely because of the intense negotiations that took place between Congress and the executive. The executive got some of what it wanted through those negotiations, like an expansion of 150 days to 210 days and a broader pool of actings to draw from beyond just people already having PAS appointments. But the executive also didn't get the things that it wanted, and one of the things it didn't get was a springback provision. So what this all kind of comes back to is, should this court be in the business of reading a springback provision into the statute that Congress considered and refused to adopt. And that then I think brings me to the last point that I want to make, which is I think the government intimates on some level that Congress could have never fathomed the situation that we present here. But if you look at the Senate committee report of the concurring or additional views section of that report, it says on page 31, the committee expects that there will never be a case where a nomination for these agency head positions is not timely submitted, i.e. within the 210-day period. This was on Congress's mind. They initially thought maybe it should be addressed through a springback provision. They simply didn't enact one.
Thank you, counsel.
Thank you.
The court will take a brief recess.